Hello everyone, it's your solicitor again, Tayo Arowojolu, practicing from London, England. I just want to welcome you to this short clip to advise and counsel with regards to how you can bring your adopted children from outside the UK into the UK. I did a part one some weeks ago, and I've deliberately delayed the release of the part two because I was waiting for the outcome of a case I had in court that's taken over 2 years, and I've been advising this particular parent for about 6 years on how they can bring their adopted daughter to the UK. Parents are both British, and they've been wanting to bring their daughter to the UK. Like I said in the part one, it's a very difficult and complex process, which I highlighted the legal intricacies in the first part. But in the second part, I want to go to the facts of the case, and if you feel on the grounds of the legal regulations and the requirements, there's a particular angle that you can use. You can use Article 8, which I will read out, and you can also use the immigration rules. This one it's not going to be a short clip because I want to go into the regulations and also the facts of some of the cases, and then bring out the principles that were set in those cases to help anyone who is interested in applying this alternative route. And so I will ask you to exercise patience as I take you through it. So I'm going to make it slow so that it can be detailed, and you can use this video to advise yourself as to whether it's an option or a step that you want to take. Like I said, it's always very emotionally draining. It can be depressing, but ultimately, like in this case, we won in court, and it's good news after all. So I just wanted to relax and enjoy yourself. I will try and explain some of the legal intricacies so that it will come out like a layman, in a layman language that you will understand. So like I said, you have two Mr. and Mrs. Who have fostered a child when the child was just 10 days old, and then subsequently, after some months, adopted the child. They made an application to the entry clearance officer in Lagos to allow them to bring the child as their adopted child to the UK. But the entry clearance officer, of course, more often than not, tend to refuse such application, and they refuse this particular application. And this is what they say. In this case, they are the respondent, and the client I represented is the child. So the child is known as the appellant. The respondent said they did not believe that the child meets the criteria set out in the immigration rules paragraphs 316 section 4, Roman 4, and Romans 7 and Romans 8. So if you are interested in this, just Google immigration rules. I will read those paragraphs for your benefit, but if you Google immigration rules and set out paragraph 316, section 4, section 7 and section 8, you'll be able to understand the details of the immigration rules. Now, what they've said is that the refusal of her application, the baby's application, will not be disproportionate, will not be a disproportionate interference with any right protected by Article 8 of the European Convention on Human Rights, brackets ECHR, which is European Convention Human Rights. And so sometime in 2020, the application was refused. To understand the delay, which I consider very harsh. We did not get a decision on that basis until last month. Okay, so the application was brought to me, the refusal of the application was brought to me, and then we appealed. Well, the good news is that we won the appeal, and is a cause for celebration and Thanksgiving, and at a time, I'm sure we will do that. But it was very complex, very complicated. We had to go through a lot of hurdles. We filed over 150 pages of documents. The Home Office, which represented the respondent, filed 79 pages of documentation, and it bordered on Article 8 and the immigration rules. But I also want to share briefly a side legal hurdle that we had to cross. Nowadays, if the parents are outside the UK, especially in this case it's Nigeria, you will have to apply for leave. You go through the Foreign and Commonwealth Office to apply for leave to get the permission of the Nigerian government for them to give evidence online, and that in itself, or electronically, and that in itself posed some difficulties. We had to pay fees to the FCO, Foreign and Commonwealth Office, or FCDO, and or give evidence on papers. And I felt giving evidence on papers will not bring the natural parent emotions of the parents, and I wanted them to give evidence orally, but they're based in Nigeria, so we had to apply. But that took quite a long time. By the time the case came up for hearing, we didn't want to adjourn again, so I had to counsel and advise the parents to allow evidence on the papers, and that's what we did. I will go through some of the facts to help you understand how you can apply under the Article 8 and the immigration rules in case you failed on the protocols and all the de facto adoption processes that I highlighted in the first part. So the issues in dispute between ourselves, representing the appellant, and the Home Office, the respondent, are the following. Number one is Article 8.1 of the ECHR. I'll read that later. Article 8.1 of the ECHR, engage, i.e. the appellant, we say it is engaged. The respondent, the Home Office, said it may be engaged. It may be engaged. The second issue is can and will the appellant be maintained and accommodated adequately here without recourse to public funds in accommodation that the adoptive or adoptive parents own or occupy exclusively. The Home Office is always wanting, coming over to ensure that, to confirm that they have adequate maintenance, that they are financially capable of looking after anybody that they're bringing, and also whether there's an accommodation so that you won't have to rely. When you see the word rely on public funds, those words are basically just saying we don't want you to come and enjoy any of the benefits that are being set aside for our own people here in the UK, although the people that are on social benefits or whatever it is. The third issue is whether the appellant as a child has lost or broken or intends to lose or break ties with the biological mother, what we call the family of origin. That's one issue that we need them to satisfy. And also with the appellant, the child, be adopted in the UK by the adoptive parents in accordance with the law relating to adoption in the UK, and the proposed adoption is not one of convenience arranged to facilitate admission to the UK. Some people do that. They just want to bring someone in and they will say it's a legal adoption, whereas it was set up for convenience. And lastly, the last issue that was before the court is whether the respondent's decision is a disproportionate interference with the right to a private and family life protected by Article 8 of the ECHR. The legal framework of Article 8 of the ECHR, which is the European Convention on Human Rights, is as follows, and I'm going to be reading from my screen. It says it's a right to respect for private and family life. Right to respect for private and family life. Number one, everyone has the right to respect for his private and family life, his home and his correspondence. So that is a right that is enshrined in the Human Rights Act. So it says everyone has the right to respect for his private and family life, his home and his correspondence. So nobody can just come and interfere with your private life and family life. They can't interfere with your correspondence, and they can't just come into your home anyhow. The second leg of that article says there shall be no interference by a public authority with the exercise of this right, except such as it is in accordance with the law and is necessary in a democratic society in the interest of national security, public safety, or the economic well-being of the country, for the prevention of disorder or crime, for the protection of health or morals, or for the protection of the rights and freedoms of others. So, number one can be breached if it contradicts the second leg. Now, the test for whether an immigration decision breaches Article 8, of course, is a 5-stage test in a case known as RAZGAR. RAZGAR is RAZGAR. It's reported in 2004. You can Google it and understand what it says, but I will just state the 5-stage test so that will be for your benefit. If you're not a lawyer and you're interested in just knowing how can I succeed in any case that are brought under Article 8, these are the things that the court will look at. Number one, will the proposed removal be an interference by public authority with the exercise of the applicant's right to respect for his private, or, as the case may be, family life? Number two, if so, will such interference have consequences of such gravity as potentially to engage the operation of Article 8, the one I've read earlier? Number three, if so, is such interference in accordance with the law? Number four, if so, is such interference necessary in a democratic society in the interest of national security, public safety, or the economic well-being of the country, for the prevention of disorder or crime, for the protection of health or morals, or for the protection of the rights and freedoms of others? And number five, which is the last criteria, if so, is such interference proportionate to the legitimate public end sought to be achieved? So there are cases already decided which will help a judge looking at any case under the Article 8 with regards to any matter, which will be helpful for them if they follow the criteria that I've set above. If the criteria are met, then straight away Article 8 is engaged, and then whoever is bringing any case or any appeal under Article 8 is mostly going to be victorious. That is the essence of that. And the refusal decision would be disproportionate, and there would be no further need to examine the entirety of the case. So that's the Article 8 right. Now let's look at the immigration rules. The requirement for limited leave to enter the UK with a view to settlement as a child for adoption. 316A, the one I referred to earlier, this is what it says. The requirements to be satisfied in the case of a child seeking limited leave to enter the UK for the purpose of being adopted, which for the avoidance of doubt does not include a de facto adoption. I explained that in the first part of this video. In the United Kingdom are that he, subsection 4 or subsection 4 can and will be maintained and accommodated adequately without recourse to public funds in accommodation which the prospective parents or parents own or occupy exclusively, and section 7 has lost or broken or intends to lose or break his ties with his family of origin. Those are the biological parents. And section 8 will be adopted in the United Kingdom by his prospective parents or parents in accordance with the law related to adoption in the United Kingdom, but the proposed adoption is not one of convenience arranged to facilitate his admission to the United Kingdom. Now, this is very important. I explained that some people would do adoption just to facilitate the immigration of a child to the UK. Now, there's a particular case. I don't want to confuse you, but the case is TY. At times they don't want to reveal the name of a child because of the vulnerability. So this one is TY in bracket overseas adoption certificate of eligibility, Jamaica. The case, the head note on which the case is based is as follows. In cases where an adoption is not recognized by the law of the United Kingdom, the tribunal should be aware of the underlying legal process in each part of the kingdom by which a certificate of eligibility is issued. Number 2, the certificate of eligibility is the definitive outcome of the fact finding and assessment that underlines it. Okay, and so on and so forth. I don't want to make it too technical, but all of this is just saying that in looking at immigration rules, you need to weight against the fact of the case and the certificate of eligibility, so that it can inform the decision to be made on the application for entry care. Okay, you also need to know that there was another case that was decided some years back, that the president of the tribunal actually stated that in recognizing adoption of what they call foreign adoptions, there are 4 criteria, generally in legal terms known as Valentine settlement, which would normally apply in cases like this. And I will just give you the criteria, 4 of them. It says the adoptive parents must have been domiciled in the foreign country at the time of the foreign adoption. Okay, secondly, the child must have been legally adopted in accordance with the requirements of the foreign law. Number 3, the foreign adoption must in substance have the same essential characteristics as an English adoption. The concept of adoption in the foreign jurisdiction substantially conform with the English concept of adoption. There must be no reason in public policy for refusing recognition. So that's very important. If you're interested, I would expect anybody wanting to bring a child to the UK on this basis to read up all these things that I have identified. So in this particular case, the judge held that Article 8.1 of ECHR was engaged. The respondent, i.e. the Home Office, accepts that the appellant has been adopted by the parents in Nigeria. They do not challenge the evidence that the parents adduced, but what they're saying is that she may have a family life with the adoptive parents, but they maintain that the decision to refuse her entry clearance is proportionate and does not fall foul of Article 8.2 of the ECHR. Okay, the judge said, well, it is not clear whether the respondent accepts that Article 8.1 is engaged, and so for the avoidance of doubt, she determined the issue there. She just said, after considering all the other facts, and the Ragsgar principles said Article 8 is engaged, and we succeeded on that ground. By the time we came to court, and amongst the document, 150-page document that we filed, the judge was able to see, and I'm reading from paragraph 25 of the decision. I said, in light of the foregoing, of foregoing, in addition to the length of the caring relationship, akin to, if not de facto, that between parents and a child, including the appellant in this case, living with them and only them since October, almost about 4 years ago, when she was just 1 year old. They are taking full responsibility of her care, attendance at nursery, housing, food, medical care, and financial support. The judge said she was satisfied that family ties have been created between them and maintained, and have endured for the last 3 years of the 4 years of the appellant. Indeed, she said that it is likely that she cannot remember a time before the adopted mother became a primary carer. So she was fully satisfied, and again, on that basis, we succeeded. The second category is whether the adoptive parent can maintain and accommodate the appellant adequately without recourse to public funds, that is seeking benefit in the accommodation that they own or privately occupy exclusively. This is one of the most. Is one of the simplest criteria, because the parents are financially stable, they have a house here, the income is good, and the judge just checked the documentation, and she was satisfied that the parents will be able to maintain and accommodate the appellant in their own house, and it was a walkover on that point. The third criteria is whether the appellant has lost or broken or intends to lose or break her ties with her biological parents or biological mother, that's family of origin. Now, in this instance, you have to show documentation, letters written by the officials from Director of Child Development at the Ministry of Gender Affairs and Social Development. You have to show evidence that after the child has been adopted, the biological parents have not continued to come to the adoptive parents to ask after the child or to attempt to see the child. All those things can be proved by documentary evidence, because in Nigeria, the Child Development at the Nigerian Ministry of Gender Affairs and Social Development will investigate, will check all the things, check that all the I's are dotted, the T's are crossed, and once they issue a letter to the effect that there's been no interaction between the birth mother and the adoptive parents, then that will satisfy the court, and that is very key, because what you have is some adoption initially may be difficult for the biological parents to leave their child, and then they keep on speaking to the adoptive parents, and then they begin to engage, and all the emotional and sentimental ties, but you have to show that the parental ties between the biological parents and the child that is being adopted is completely broken. And again, like I said, letters from this department in the ministry and any other documentary evidence to show that there's been no interaction will be very helpful. Again, we succeeded on this ground. Now, because the adoptive parents are bringing the child over to the UK, they must be able to demonstrate that the appellant, the child, will be adopted in the UK, irrespective of whether the child has been adopted in outside the country or in Nigeria. For this particular case, that the child will be adopted in accordance with the law relating to adoption in the UK, and the proposed adoption is not one of convenience. Again, I'm repeating that, arranged to facilitate admission to the UK. Now, first of all, our witness statement on this point was not challenged. The judge looked at the case in its entirety and said, look, these people have adopted the child, they fostered the child, they've adopted the child, they've spent money on her, looked after her, they've gotten all the necessary parental responsibilities passed. They wouldn't have wasted their time really in doing all this, abandoned their home here in England and then going to Nigeria to settle for going to 4 years, if not 5 years now. And the judge said she's satisfied that when they come to the UK, the natural thing to do is to put the record straight and proceed to adoption, which again they have enough and sufficient evidence to be able to adopt the child in the UK, because that is essential and crucial. So again, we're able to persuade the judge that we'll be able to do this, and again, we succeeded on this ground. Now, I need to mention that because this the law that was considered in Nigeria is the adoption law in Nigeria and the processes, we had to engage an expert in Nigeria. We got an SAN, Senior Advocate of Nigeria, to write an opinion on this, and which we lodged in court as part of our documentation. And the judge read that and was able to pick out positive points that worked in our favor. And that's an independent barrister in Nigeria that would look at the law and look at the adoption law here in the UK and compare. And similarities were found, and so it was easier for us. Well, I say easier now, but it was easier for us to be able to say, well, the adoption processes are the same. Article 8 is engage, immigration rules, the paragraphs in the immigration rules are engaged, and there shouldn't be a problem. Well, the judge said we succeeded on all grounds, and she said, and I'm going to read her final statement. She said she's satisfied on the balance of probabilities, because that's what you need to prove in immigration appeals, balance of probabilities that the appellant, that's the child, satisfied the requirements of the relevant immigration rules. And she said being also satisfied that Article 8.1 of ECA child is engaged, that she concludes that the respondent decision being maintained is a disproportionate interference with the appellant's right to respect for a family life and unlawful under Section 8 of the Human Rights Act 1998. And she said the appeal succeeds. So it was a victory that we should really be popping some bottles. But we thank God that everything went well. Now, the good thing about this is that the judge also made a fee award. I just want to say that even though this matter took years, because the parents, adoptive parents, they want to do anything illegal. They wanted us to go through the processes and ensure that when they bring in their child, the child will have no fear, have no wrong foundation, and they will be able to bring their child into the UK, and the child will be a British citizen after the adoption in the UK. And I'm so glad and pleased that we've been able to satisfy some parents who, if you look at the case, they've had a lot of waiting for the fruit of the womb, done several IVF, tried surrogacy, and when all failed, they resorted to adoption. And the Home Office was going to make life difficult for them. And so we thank God that we're able to bring some smiles to some faces. And I'm really, really looking forward to meet the child and the appellant and give her a warm embrace. Now, if you enjoy our clips, we ask you to share as far and wide, as many as possible, and look out for another video in future.